NCDG Realty Management versus Guy, is it Gaboldo? Gaboldo, I think it is.
Bodo, that's correct.
Good morning, Your Honor. Sumchit Hart, P69542, on behalf of plaintiff.
All right. Good morning.
Good morning.
All right. And what is plaintiff's claim in this case?
Your Honor, this is a termination of tenancy case where the lease is expired on September 1st, 2025. So we're just seeking to recover possession of it.
All right. And sir, what is your position on this?
My position is, in fact, the opposing party been discriminatory, biased, mafia, Ku Klux Klan. I left that property on October the 16th. I called the opposing party and I asked them, could I pay? October is paid. I say, could I pay for November and December? She said, yeah. Great. I said, give me a couple of days. I'll make the payment. No problem. Then in an hour and a half, she said, you got 2 hours to pay it.
Okay, sir, are you going to get an attorney to represent you?
Well, no, I'm not going to get an attorney, but I've been out the property. They asked me to leave. I left. She said, you come up with the money or leave.
Okay, so
I'm not in the property. They can have
so, sir, all they're asking for is possession, but you're telling me that you're not in the property.
Exactly. I was told to leave in 2 hours and I left.
Okay, but that's not my question. My question is, you said you're no longer in the property. Is that right?
That's correct.
That is correct. So if they were to go in to the property, you don't have anything there or anything else, so they can take possession of the property.
That's correct.
Okay, that's all that they're asking for.
All right.
So what I will do is I will indicate that the defendant is indicating that he's voluntarily surrendered the property. And then Ms. Hart, I'm going to put it over to next week, let you guys check. And if not, then the matter can be dismissed, I guess.
Fantastic, Judge.
Or if you do get possession, matter can be dismissed. If you don't, then we'll have to set it for something else.
Thank you.
Well, I didn't volunteer. They told me to leave. So I was forced to leave. No stove, no oven. I was forced.
Well, sir, if you feel somehow, sir, I'm just going to say this to you. I'm going to put this over. Actually, it's going to be 2 weeks because of Thanksgiving. I'm going to put this over. If you feel that there is some claim you wish to pursue, you're going to have to file the requisite pleadings, and then we will deal with it in 2 weeks. I will adjourn this matter to
That's okay, Your Honor.
December 5th, 2025 at what time?
I won't be available.
At 3 p.m. That is an in-person proceeding. So if you wish to continue with the matter, you'll need to show up at that point in time. Thank you. Have a great weekend and happy holidays to you.
This is a common misunderstanding. Forced versus voluntary doesn't matter if the result is the same. In housing court, outcomes matter more than motives. If the unit is empty, the court treats possession as resolved. Full stop.
Court calls case of Arbor Woods versus Kelvin Jones. And Josephine Watson.
Good afternoon, Your Honor. Sydney Fontanella, P86316 for the plaintiff.
Good afternoon.
Good afternoon, Judge. Your Honor. How are you?
I'm fine. You gonna yell at me?
No.
Okay.
I had oral surgery Wednesday in my mouth, so I ain't hollering at nobody.
You and I okay. All right, then I can say what I want now.
Yeah.
Yeah.
Well, as long as it's nice.
As long as it's nice.
Yeah.
Okay. Where are we on this case?
Your Honor, I had emailed over a ledger for your review yesterday, as well as an email to Miss Watson as well. This is a case where last week we had discussed that we believe the balance had kind of been compounding. I went through the ledger, I combed through it. There was a credit at the end of March, and then it looks like they were short $60.55 in April, $10 in May, 20.75 in June, 20 cents in July, and then another $9.94 in October. There were late fees that were assessed from April through November as well.
Got it. Do you see that, ma'am?
We have never been late. We've never been short
Well-
$60. And my money order receipts are in the car,
hold on.
of course.
But here's the thing, that was in March, right? March going into April.
So yeah, there was a credit at the end of March of, I believe, $88 and I think it's 65 cents. That was a credit at the end of March. And then there was a balance at the end of April of $60.55. The rent was not, the April rental charges were $904.95, and they only paid $755.75, which left them with the balance of $60.55 due.
Got it.
And then that kind of situation happened for May. They were $10 short. For June, they were $20.75 short. And so on and so forth, as I already had described.
Well, how come I wasn't notified of this? How come we weren't
Hold on a
notified?
sec. Just hold on a moment.
Yeah,
Did
'cause
they, I don't know what the complex's policy, would they have sent a notice to quit? For a $60 balance, they probably wouldn't have.
I don't think so, Your Honor. And if I'm being candid with the court, there was some new management that joined back in, I believe, May of this year. And so if there was some sort of communication issue between covering managers from April and May, I think that's kind of how things have kind of gotten kicked down.
How things got up. And
Yeah.
so each of those months, while the balance is minimal, they're accumulating a late fee.
Yes,
Twice a month.
Yes, they've been accumulating late fees for each month as well. Although I will say that there was not a late fee assessed for April. There
That's
was,
what I was.
yeah, there was a $55 late fee assessed for May. And then there's two late fees that were assessed for June. There was a 55 and then a 30.
Small shortages snowball into late fees, then compound month after month. Even if rent is mostly paid, courts often side with the ledger, not the explanation. Viewers, should landlords be required to notify tenants when balances start compounding, or is it strictly the tenant's responsibility?
And then I'm looking again for July 55 and 30, August 55 and 30, September 55 and 30, October 55 and 30, and then same for this month, 55 and 30. Your Honor, I don't have a problem if you would like to adjourn this for an in-person bench trial to review in depth. I can also talk to my client about any potential settlement authority as well. If I could, I know that I have Ms. Watson's email address. I would just request that she provide Anne her phone number so that I can get it. And if I'm able to get any settlement ability, then we can discuss between now and the bench trial.
That's what I would like to see happen. Okay. What I'm going to do is I'm going to adjourn it to a trial date, right? In the meantime, it's going to try to get settlement authority for some of this with her client. All right. Now, the only thing I'd say to you is it can't be an all or nothing, right? So from your standpoint, so while you haven't, at some point you were late. The problem that's happened, well, not late. Well,
Sure.
Everything wasn't paid. Yes, you were short. You weren't late. And I
Right.
think that's kind of a misnomer. But the problem is that being short, it just compounded. And you're right in certain respects that then you're not notified.
Right. I mean,
Right. I get it. And there are some things in terms of how that kind of thing happens. do they have to notify you? No, they really don't. But should they have let you try to make? If I looked at your ledger when I was going through it, I said, well, I would have probably reached out to you and said, look, you got this issue here. I mean, I may have let the 1 month pass thinking, okay, something happened, they don't. But then the next month I would have done whatever, irrespective of what might have happened. The thing is that then $85 is popping on each month, and you're paying, but you're again theoretically short because you're not paying. That balance is still there.
Okay.
Okay. So I think this probably the best way to do it is to just set it for a non-jury trial. And then I don't know that anybody would necessarily have to put on any testimony. I mean, I can look at it myself. I'll just skip the final settlement conference, set it for trial, and then I'll make the call on it. All right.
Okay.
But I just need you to know it won't be, even though you weren't told, you still are obligated to potentially pay some of it. Okay. So what date do we have?
December 2nd.
Give me a date after that, because that's right after the holiday. I want to make sure my sponsor has time to talk to her client. Why don't I set this for December 16th? It's not as though they don't pay.
That's good.
Will that work for you?
That'll work for me. Yeah.
December 16th,
Red have surgery.
2025 at 9 a.m. And he's at work.
Yes.
'Cause
Calvin.
yeah. Because at the time she stopped yelling at me, he yelled at me about, I'm like, man, I'm just doing my job. So we'll set it for 9 a.m. They'll be in contact with you to see whether or not you get it resolved before you get to that point.
Okay. December 16th.
Yes.
Could she just provide Ann with her phone number so that I can have that and Ann can message it?
Oh, okay. And if you can provide a phone number to my clerk, and we have permission to send that over, ma'am.
All right.
To them.
Thank you.
Okay.
Thank you, Young.
Thank you.
Thanksgiving.
Yes, and happy Thanksgiving to you. Sparrowwood Apartments versus Michelle Shimon. Yes, I am pronouncing everybody's name wrong, so I'm gonna say whatever.
Good afternoon, sir.
Good afternoon. Can you state your name for the record, please?
Certainly, Michelle Shemiat.
The last time that we were here, you said you were going to move. Okay, where are we in that process?
I'm still working on it. I can update you on a couple of things.
Surely.
I've arranged my mover with my helper that lives with me.
Okay.
So I've got that arranged. I'm still pitching and packing and looking for a place to live. Because of my disabilities, I'm finding that yesterday I was at a place in Ypsilanti that was reasonable, but the railing outside was too wide to grip to get up 2 steps that were too high to walk up unless the maintenance man came and lifted me up and got me in. And then when I got in, the bathroom was so small that I couldn't get my walker. I just could get my walker in the door, but there was no space in the bathroom to turn my walker around.
Okay.
It was really cramped. I'm finding things are not accommodating for my handicap. Ms. Linton has told me that she could do a reasonable modification request. But the fact that I couldn't manage in the bathroom and I don't know what they can do about the step going into the apartment. A ramp might work, but the bathroom just didn't work. While I'm here in court, we were looking at Beale properties. I'm looking on Craigslist and I'm finding better places there. And I'm going to be making some calls starting tomorrow. Let's see. And a lot of apartments that are available have stairs in them, so I can't go up and down stairs, blah, blah, blah. And I still want you to know that as soon as I'm settled, I'll be starting to make payments to Sparrowwood. And if I get a decent amount of my damage deposit or my security deposit back from them, that'll be my first payment. It's $855 is my security deposit. There is some damage done by my live-in helper on a closet door, putting his scooter in the closet. So if he can't fix it, then they'll probably charge me for that. But anyway, that's kind of my situation. I'd like to request more time. I'm still working regularly to try and find a place. And that's about it.
All right. Anything from the plaintiff on this?
I'm sorry.
I was asking if they wanted to say anything before
I don't have authority to stipulate to an adjournment, and I think my client would likely ask if there's any way that, if this is gonna get adjourned, if there's any way that if Ms. Shemiak could put December's rent towards the balance, but I understand that is subject to
I am getting my Social Security check next week, so I'll have that money to help me get out. Okay.
Sherry-Ann, let me tell you something. First time I saw you on Zoom, one of my impressions of you were just a really proud woman who was trying to make do and do the best that you could with where you are. And every time that, since you've been coming in person, you come here, you give me an update about where you are. And you have a stated goal in mind, but trying to get there.
This is rare. Judges don't usually speak like this. When they do, it means credibility matters. The court isn't ignoring the law. It's weighing hardship, consistency, and good faith effort. This is discretion in action.
Isn't easy. And for you, there are even more barriers, like you said. You're trying to find some place and you can't even get up the steps to get in.
Yeah.
And then you get in, and even if that were resolved, the unit itself isn't functional for you. And those are different barriers that a lot of us don't have to deal with. But, you know,
I'm finding better examples right now on Craigslist while I've been sitting here in court. And I plan to call Wood Creek Apartments, see if I can find something without the stairs.
but here's the thing. A lot of people, when they find themselves in that position, get angry. They get mad at the world. They want to, I don't know, yell at everybody. And I know you look at me kind of confused because that's not you. And I don't say this to defendants much or participants in the court, but when you come here, you are just a joy to listen to.
Oh, thank you, Judge.
And to just listen how you try to work through the process. Okay? And I know you're doing everything you possibly can to move. I mean, you know, you saying I'll move, and then you are telling me you even are trying to set up a plan to as to how you're going to get them paid back. And what that really just tells me is that you're just a person that just tries to do the right thing.
Thank you.
All right. So your social security check comes in, right? But you need that to move.
Absolutely.
Okay. So here's what I'm going to do. Because otherwise she's going to be between a rock and a hard place. I understand a reserve ruling on plaintiff's request for escrow. I will not order any escrow for rent at this time. Okay.
I can't hear you. I'm
Probably
sorry. Could you speak
because
up?
I'm sorry.
I can't hear you.
You couldn't hear
Speak
me.
up.
I'm not going to order you to pay any money into court escrow at this time
Thank you.
because you're going to need it to move. And based upon what you're telling me, I think when all of this gets down to a certain point, you're going to try to find a way to make it good because that's just who you are. All right. And that's just in all honesty in my heart what I believe.
Thank you.
So I'm not going to do that at this point. And I'm going to adjourn this out. I'm adjourning it out over the objection of plaintiff. All right. Ma'am, and I know probably every night you sit here and worry about this, right?
Yeah, I'm working on it every day.
I know that you work on it, but you're worried about it, right?
Yeah.
It's one thing to, all right, so let's do this. Yeah, and I'll just tell you this. I'm not letting anything happen to you. All right? I'm going to give you the time that you need to try to do what you're doing. All right? And so I'm going to adjourn this out. And again, this is over the objection of plaintiff, but I'll adjourn it out at this point to December 12th, 2025 at 2 p.m. I would go out a little bit further, but I want you to come back and see me.
Well, we'll probably both gain a little weight from Thanksgiving.
Yes, absolutely. That's it.
Said December 12th at what time?
At 2 p.m.
2 p.m. Oh, thank you
Yes.
very much. I
You're
really
welcome.
Appreciate it.
And you have a very wonderful and blessed Thanksgiving.
I've got my frozen healthy choice meal with turkey in it, so I'm going to be happy.
There you go.
Thank you. I'm sorry, Judge. I
No, it's okay.
appreciate everything.
I've been
Great
called
holiday.
a lot of things. I'll take that one.
Thank you.
All right. Take care of yourself.
You have a great reputation, by the way. You know,
Pardon?
you have a great reputation, by the way.
I do?
Oh, yeah.
Well, thank you.
People I know you well and love you.
Thank you, ma'am.
Thank you.
Thank you very much, John.
Thank you. Have a good Thanksgiving.
Thank you.
Court calls the case of Pleasant Lake Park versus Christopher Janowitz.
Happy to see you, Judge. Happy to see you, Mr. Allen. I have documents to submit.
What? Oh, just
David Morse on behalf of Plaintiff Pleasant Lake Park, LLC.
thank you.
Thank you.
Your name, sir?
Christopher Genoviak.
Okay. And what documents are you trying to submit to the court?
A counterclaim.
Have you?
Judge.
So this is our fourth hearing. Last hearing, plaintiff presented an inspection, an unsworn statement by an inspector, and Mr. Genowiak asked for 1 week to get his own inspection done. I understand that he has done that. He provided me a copy of an inspection report today, just before the hearing, and I understand from the Register of Actions that he filed a motion to set aside default, which maybe is the counterclaim. I'm not sure.
I don't understand how I submitted one. I don't know if I did that. I don't understand how I submitted money. I don't think I did that correctly.
How you what?
The money that you ordered to put in escrow, like,
Yes.
it's like a holding, like, you know, you may give me all the money back, hypothetically. I don't think I submitted the money correctly. Because I don't want to like escrow. I put 1230 in escrow because there's a $20.
Where are they putting this over here?
They also made him fill out this form. That's why.
Oh, I see.
I told you about
Yes,
that.
you
Yeah.
did.
Yeah, I think I did that.
No, the money, the escrow's there. We had a clerk that, I don't know why they did this. What they did, counsel, is apparently the only way that they ever saw escrow come in without an understanding that I ordered escrow was on a motion to set aside.
I see.
And so they had to fill out that form, which really means nothing because there is no judgment had they looked.
Yeah, I'm ignorant of my actions. I don't know.
No, it truly, sir, there may be other things that are your fault. This one's not. So, well, okay. You can hand it to me when I want you to hand it to me. You really do not have to bow. Okay. Have you seen the counter complaint?
No, I'm not aware of a filed counter complaint. And for the record, I haven't seen a copy of an answer, haven't seen any writings by the defendant.
Okay, so let me just back up a second. What did your report reveal?
It revealed conspiracy and perjury by the landlord, Mr. Weasel. And
Oh my gosh.
investigators.
No. You had an inspection.
Yes.
Or
The inspection determined that there is a complete infestation
of what?
of rats. A complete infestation. There's rodents everywhere. Throughout the home in areas like the rotary room and wide open, and you shouldn't see this is usually a sign of an infestation. The loose material underneath the dresser behind the stove is from the rats trying to create a nest. The loose material behind the stove is from the stove's insulation. And be very.
Who's this from?
It could be a fire hazard. This is from a company called Proof that has over 100 years. And I have colored photos and I have some junk. It's licensed and insured.
Okay. Just let me.
Would you like a copy?
Thank you.
Thank you.
I gave the kind lawyer a copy of this. Sorry. I don't know if that's that you give him what I gave you.
Yes.
Okay. So we have. Right. That is what I have. So the most sort of technician comments. There are more pictures I did not.
Okay. Were these pictures a part of his report?
Yes, sir. Yes, Judge.
Okay.
I haven't slept a single night since August. I called the police twice because I thought there was people outside my house, but it's really just a rat infestation. I've tried to get resolved and they wouldn't do walkarounds. So since August, I haven't
called the police on the rats?
This is the rats, yes. There was more creatures. The whole house was just, there was holes in the skirting and there's proof. There's holes in it underneath the cabinets that are connected to the wall. It's a complete rat hotel. I hear them every night. They chew my property. This is complete opposite of what this client said. His inspector is my next door neighbor. There's a conflict of interest in here. There's conspiracy. There's perjury. I might take this to trial to get them on record, so I can later sue them.
Okay.
I might take this
All
to trial
right.
to get them on record.
Okay. All right.
I might. You're judge.
Well, we welcome any trial if you would like to file an answer and a counter complaint. Your Honor, frankly, this is the first that plaintiff is hearing of rats. And this whole case it's on non-payment. For weeks or maybe months, the defendant has been complaining of a beaver or a badger under his premises. My client has been taking steps like trapping, poison, inspection under the premises, outside of the premises. We file a non-payment complaint, and the defendant Still did not raise this issue. First hearing, second hearing.
Oh,
Again.
trust me, counsel, I remember everything
Thank you, Judge.
on this, and I just. What's in your counterclaim?
My counterclaim, Judge, has a photo evidence of a complete rat infestation, the complete opposite of what.
Okay, but is that the counterclaim?
I mean, this is enough for his client to be convicted of perjury and conspiracy.
I don't know what that. I don't know what that means. I'm just asking. Is that your counterclaim?
Yes, Judge.
Can I see that? And counsel, I'll let you take a look. I'm trying to. Oh. It's the report.
Yeah, that's fine. Yeah, this just proves everything that he's been saying the whole time. Because this is a licensed and insured rodent pest control with over 100 years of experience. And his rodent and pest control man lives on the same property that Mr. Weasel owns, which is a conflict of interest. And he's not licensed or insured. The inspector doesn't even own his own vehicle. He lives with his kind elderly father. And he used this.
Sir, do you understand that
I don't understand.
is not, it's clear that is not a countercomplaint.
Should I put it in writing?
Well, that's usually where it starts.
Okay,
Yeah.
I know there's an order of operations and proper, ways of operating here. I thought this was sufficient for the court, that this is a professional who is licensed and insured with multiple lines contradicting the plaintiff's claims. And I want to make a deal. I want to leave. I feel like I'm being attacked.
You want to go?
My deal is, my proposed deal is not a serious one.
Courts don't run on stories, they run on pleadings. Photos, reports, accusations mean nothing unless they're filed correctly. Miss the paperwork, miss the deadline, and the court can and will grant possession by default. This is where cases are truly won or lost.
I do want to go, but
I don't know what that means.
yeah,
What do you mean?
I would like to hear a deal. I could propose a deal, but I mean, I really want to stay here and get this rats out of my bedroom. It's literally in my bedroom. It's literally I have a stick just to poke the rats underneath the dresser. I literally have a rat stick next to my bed. For the record, I literally have a rat stick next to my bed for 5 months. So I could put this in writing. And I'm sorry to waste court time. I've been trying to make a deal, but I tried to do a walk around and I tried to do a proper investigation months ago, but
Hey, sir,
yes,
there are certain ways that you would have to do an answer and a counter complaint. Okay? And you need paragraph by paragraph laying out your allegations as against the plaintiff, as well as answering the plaintiff's claims in this case. You follow me?
no, I don't understand. I thought I did that when I first did the paperwork for the contract. Like, it says like, how do you respond to the claims? And I was just like, yeah, I disagree with everything but like the money portion. So, I just thought this was like pretty cut and simple. Like, if there's a fly in your steak, you're not going to charge it with potatoes.
But sir, you started out with like a beaver or some large like badger type animal under there. Then when you came back the last time, we weren't talking rats. You were talking about mice and the baseboards being ground zero and all of that stuff.
Yeah.
Now I get here today and now these mice have grown and now they're rats.
Oh yeah, the problem's gotten way worse. I agree with you, Judge. Problem's way worse now.
You're not really saying the mice grew into rats.
I'm saying that the rats have been there the whole time and that we haven't done a proper inspection. We haven't done it proper since the get.
All right.
Sorry, Judge.
Sir, go ahead.
It's plaintiff's position that to the extent this is a defense about habitability, that this is the tenant's willful and that the tenant has caused these through irresponsible conduct and or lack of conduct. To the extent he has a rat stick or anything else, this is the first plaintiff is hearing of it. This should have been.
Heard a rat stick.
This is to the extent the landlord should have trapped, should have baited, should have taken any steps, we needed to have been made aware. We were not made aware. It's clear to me that defendant has taken no steps, no meaningful steps to resolve the issue. His living conditions invite the issue, and that we can't be in a position, the landlord cannot be in a position to check in on the defendant to ensure that his quality of life is where maybe it should be. I submit to the court that there is no tribal issue here. To the extent the court disagrees or believes that there should be another chance to file something in writing, I think this needs to go to a trial, a short trial.
I want a bench judgment.
I'm sorry?
I want a bench trial. Judge.
Well, that's all you're entitled to at this point because I don't have a jury fee. So
Correct.
So
one other point for the record, Your Honor, is that management understands that. So there have been attempts to go out for the beaver or badger, and there have been attempts to assist with skirting and other various issues raised over the months. Management has been responsive, but understands that there was at some point, defendant in the last month or so made a comment to a neighbor saying that he would shoot management if they came and knocked on his door. He also claims that management has stolen hamburger off of his counter. So we're not sure if these allegations or threats are real, and we have to assume that they are. And this is part of management's concern, is that, frankly, that the situation has broken down, and I think a trial would show that there were no attempts to bring management in on the rat, the mouse, or other issues other than the badger or beaver, and those have been proven or shown through the unsworn statement to be flatly false. Mr. Janowiak's inspector clearly did not see any signs of a badger or beaver either.
hey, so how long is it going to take for you to put your complaints in writing to the court?
I don't understand what I should put.
Well, you're going to need to understand.
Because I thought this was, so I know I'm not asking you for legal advice.
Good,
But
I
need to
don't
just-
give it to you.
Right. So, and I this is quite the maze. And that's my ignorance. So I could put something in writing within 7 days, once I understand what to put, that's gonna be acceptable to the
All
court.
right, you're going to need to get to figure it out in the next 2 days. The defendant to file a written answer.
Written answer to what? A written answer
To the complaint.
to the complaint, and the complaint is what, Judge? I don't know, I don't understand what the complaint is.
All right. You got served with a complaint. That's what brought you here. You need to file an answer to that complaint. And if you got a complaint against the landlord, you need to file what's called a counter complaint, or your complaint against him. That you keep trying to hand me is not a complaint. It is not a counter complaint. It is nothing for the court at this point.
I don't understand it. So I will submit what so
You're to file a written answer and or counter complaint.
to the.
You're to do that by December 3rd. filing of that will only be complete once you file it with the court and you serve counsel with a copy,
I don't understand how to serve counsel.
usually by email.
I don't have proper access to email all the time. That's why there's like lack.
Okay, get a stamp, put it in an envelope and send it to him.
Got to get it twice a year, basically. Judge.
No, you gotta, when you file it with the court, you have to serve them a copy because you have to acknowledge that you've given them a copy of what you're filing with the court. Then, so you're to do that by December 3rd. I will give you time to look at that. I'm gonna go right to final settlement conference on it. And so I'm gonna set a final settlement conference on this case, which is the step before we go to trial. Set that for December 9th, 2025 at 9 a.m. That is in person, and all parties must be present. Now, I'm going to let you know, I want you to understand this, sir. I have a lot of latitude if you don't follow the court's directions. So if you don't file an answer or a counter complaint, but if you don't submit something in writing in its proper form, I'm going to grant them possession. I'm going to grant them a judgment. I'm just going to let you know that.
I will submit a written response. So,
Is there anything else?
no, Judge.
I have great trepidation to ask.
What trepidation?
Never mind.
Could you define that?
Never mind. No.
I don't understand what trepidation.
I'm saying I didn't really want to ask you if there's anything else because I didn't want to hear anything else. All right? Just to be blunt about that. But as a matter of courtesy, I have to make sure that everybody's been heard.
Yes, Judge.
Is there anything else?
No, Judge.
Sweet. Thank you. Everybody have a good holiday. Is this your only copy, counsel?
Yes, it is.
All right. So I'll. Court could stand in recess. I'll be right back, I swear.
All right.
Fixing housing, 401k plan versus Erica Ward.
Good afternoon, Your Honor. Steve Otherly on behalf of Plaintiff Fixing Housing, 401k plan.
Good afternoon, Donna Tope on behalf of Erica and Aaron Ward. They are the tenants in this lease.
All right. Where are we now, folks?
So my understanding is after the long conversation that we had last Monday, that this hearing was held in anticipation of my action or interaction. And I would, if I filed a withdrawal, then the hearing wouldn't be held. And
If you filed it with, I don't think I said that.
well, you didn't say it, no. But you said that if circumstances worked out the way you were suggesting, there were two choices, and that's why this hearing was being held. Do I not have it correct?
I don't know what you have. Keep going.
Okay. So I'm here because I would like to make this statement to the court on the record. This case is a landlord-tenant case. I repeated that in our answer that was filed with this court. The lease is not a commercial lease. As plaintiffs and this mentioned several times, the lease is between an LLC landlord and a married couple, Erica and Aaron Ward. The lease specifically states the lease is for their use as an animal farm. The property is zoned agricultural and has been used lawfully for over 25 years as an equestrian center with several major outbuildings and one residential unit. This lease began in 2021, just 3.5 years ago. The lease terminates in 3.5 years from now. None of the land is zoned commercial. None of the property is used commercially.
Why are you telling me this now?
And the lease is not a commercial lease because several times plaintiff has referred to this as a commercial lease. And I heard
this court repeat that this is a commercial lease. There are different standards applied to commercial property and commercial property that is leased.
All right, then all you have to do is say, without this long rendition, that you don't believe it to be a commercial lease.
Okay. Well, I felt I need to just restate what I had said in my answer. It didn't seem to have been heard. I have been associated with Erica Ward.
I hear everything. Now, whether I react to it becomes a whole different thing, but I hear everything. Go ahead.
Well, I have been associated with Erica Ward for over 3 years in consultation with me as a property manager through my solo-owned property management company. She consulted with me over these past couple of years over many serious, dangerous conditions the landlord had refused to repair. I gave her the City of Ann Arbor information required to be provided to tenants by landlords and the Michigan State University Law Center's information for tenants and landlords, both of which describe the right of the tenant to withhold rent and pay for necessary repairs for the health and safety and habitability of the rented property when the landlord has refused to make the necessary repairs. Our answer filed with this court had the circuit court case attached, which was filed in July 9th of 2025. The jurisdiction for our breach of lease case was with the circuit court. And our answer describes the necessary repairs the landlord refused to make since 2023, which is his duty under the terms of this lease for agriculturally zoned property.
You
Erica
can't
Ward.
have it both ways.
Hmm?
You can't have it both ways. If you're going to claim, and counsel, before you go on, I think you need to do your legal research. If you're going to claim that this is not a commercial lease,
Yes,
and it's a 7-year lease,
yes.
then the obligations regarding repair change.
That I think that would be something to bring up by the plaintiffs to rebut what I'm saying. Erica Ward asked me to be her attorney in the middle of July to file a complaint with the court over the landlord's waste and interference with her use of the property, which had caused her damages. This complaint was filed.
I don't know why I need to know all of this.
Because, Your Honor, you have questioned my ethical ability
I
to
have not
represent.
requested, I have not. What I have said is that if indeed you took funds that were the landlord's funds, the capacity that you're operating in is going to be a problem, counsel. That is what I indicated. If you don't see it as a problem, then so be it. But I think on its face, it's a problem. Any question regarding your ethics is your own. Because I'm going to tell you I'll tell you right now, if an attorney comes before me and I think that they have done something that I can show that they have done unethical, you will be reported to the Attorney Grievance Commission in a minute. So I did not do that.
No,
So don't tell me I question your ethics. I question the question. You know what? I don't need the dramatics. Any more dramatics, you're going to be found in contempt. I'm done, Ms. Tobe.
Yes. Yes.
What I said to you and what I was indicating is that you took, as you stand before me, the wards are your clients. What I am then told is that you took funds that would have been client funds and somehow took them into your possession to redistribute. Your argument may be that you did it for other reasons.
I would like to state the facts behind the assumptions that I took client funds. I did not. Erica told me that she wanted to, I was consulting with her as a property manager. I was not her attorney.
Then if that's your position, that's your position. From the court's perspective, it looks different, which is what I was pointing out.
Yes, and you clear, and
And if I want to make an accusation, Ms. Tope, I am not shy. I will clearly make that accusation, and I have not.
You were very clear that it was not an order, it wasn't an opinion, it was words. But I tell you that words have consequences because we are on YouTube.
So does one's actions, Ms.
Yes,
Tope.
yes,
Whether YouTube or not, it doesn't matter. This is a public record.
yes.
And all I am telling you is that the court saw concern.
Yes, and I am here to address the concern so that it's on the record as well, so that,
Ms. Tope, no. I have given my admonition at the last hearing. The wards may proceed in whatever fashion they wish. May proceed in whatever fashion you wish. If I thought you were doing something unethical, I would myself remove you from the case. I have not done that.
No.
So I am done with this issue.
today. You are done with me today, or?
I am done with that issue.
Okay. Thank you.
Your Honor, this is the first I'm hearing about a property management company that's holding rent payments. I don't know who the property management company is. I don't know what the bank account is. You ordered tenants to produce an accounting. They did that. It's a mess. And my client is the one who's being prejudiced by that. Actions do have consequences, and the consequences of their agent or the actions by tenant's agent have consequences. And they didn't have the right to withhold rent payments. That's what they did. These are grounds for default under the lease. The lease should be terminated, and they have to deal with the consequences. Now, if tenants, they may have their own recourse separate from this action. That's their decision. That should not be with my client, and my client shouldn't have to keep fighting over alleged ethical violations.
They did not have a management agent. She consulted with me about my opinion for over 3 years. I had no jurisdiction over the property. It was completely Erica and Aaron's tenancy, and I was not their attorney.
So,
Was I their property manager?
So,
Yes.
it's those statements which give the court pause. When you're saying that they consulted with you regarding the property, and
Not in my capacity. I was taking writing lessons and she was telling me what was going on, and I gave her some of my advice, but not in a professional or proprietary or
you can't do it that way. Okay.
as a friend.
I think Ms. Hope's property company should be a party. She has inserted herself into this litigation. And this went from a simple non-payment of rent and has ballooned because of tenants through their council's actions. And it has become a mess.
We filed, a circuit court case was filed July 9th, long before this court had jurisdiction. In my first response as their attorney for this court, I asked for an escrow fund to be set up, a trust fund to be set up by the court. And you did that. Anything done before that was not in, there was no money put in any trust fund.
Can I just say, so this, let me just ask this. Counsel, are you,
I need to step closer to here. I'm
are you going, we can get the equipment. Counsel, are you going to file a motion to add Ms. Tope and this as a party to this action? I realize I'm asking you on the spot because you're first hearing about it, and I know there would be things to be taken into consideration in doing that.
Obviously, I'd have to discuss with my client. It's something that I would like to avoid. I think the language of the contract is clear that they didn't have the right to withhold payments and that these are grounds for defaults and that the lease should be terminated and there should be an eviction order. But if we have to keep going this back and forth way, we may have to. Especially if it's a third party that's handling funds, handling the rent funds, then we would have to.
No.
So,
Yes.
were you the property manager for them?
No.
Were you involved in the payment of funds to contractors?
Only in the account that Erica used to withhold her funds. And
What do you mean by that? Who were signatories to that account?
Erica approved all of,
Who were signatories to that account?
I was,
There's our problem.
but not my.
Okay, so no. That's our problem. So, who else was a signatory to that account?
No one else. Me and me alone. And
Okay, Miss.
the money was filed after we filed the circuit court case.
No, it doesn't matter.
And this
It
court.
doesn't matter. It doesn't matter. It doesn't matter. Do you not see a potential problem with that, Ms. Tope? That's a yes or no. If you don't, I don't know what to say.
I see that someone could make an issue out of it. And I don't see a legal problem. So when you say a problem,
Let me ask this,
yes.
since you've given that information. And just think about this for a moment.
Okay.
Whether you believe it to be true or not.
Okay.
Plaintiff claims that the tenants cannot withhold rent in this fashion or make repairs and take that off of the rent. Okay? Tenants do that.
Tenants had done that before they claimed
Whoa,
that.
whoa, 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 whoa. Tenants do that. Tenants acknowledge they've done that. And that you are the one that did that on their behalf. Why? What happens given that factual scenario, which I don't think is far from the truth based on what I know, if they file a claim not only against the wards, but also as to you?
I'd have to show why it's not appropriate. Mostly because they were notified that rent would be withheld before it was withheld, and they were notified the bank account that.
So if
Yeah.
their claim is you can't do it,
Well, I guess.
if their claim is you can't do it,
Yes,
and that the wards could not do it, but then you were the one that did it on their behalf, good, bad, or indifferent, you're the one that did it. Don't you really yourself become a necessary party to this action? And that's what I'm saying. If you're a necessary party, Ms. Tope, you can't be the attorney.
okay. Okay. I hear what you're saying.
Mr. and Mrs. Ward, do you understand what the court is indicating? I mean, whether you agree with it or not, it's not my issue. You understand what I'm getting at?
Yes.
And so that I'm clear, and what I was trying to be clear at the last hearing was I did not want a circumstance where Ms. Tope, you're brought in as a party and then your clients are left without representation. It's just an issue of the fairness of all proceedings. It doesn't have to do with whether I like somebody or not or what position I'm taking. So, Ms. Tope, with that understanding, what are we going to do? I don't want to get so far down the line.
We're off track for sure.
That what?
We are on this case. We are off track. Get it back centered. I would do whatever's required to be able to deal with the issues at hand and not clog up these proceedings any further.
I don't know what that means.
Well, I'm sorry, that's the only way I can say it.
Your Honor, we're off track due to tenants' agents' conduct by taking actions that were not allowed under the lease in the first place. And this is our third hearing in 3 weeks, and my client is going without any rent payments. He got a partial payment, but he is the one who's being prejudiced by us having to keep coming to court when tenants didn't have a right to do this in the first place. And they have to accept the consequences for their agent's actions.
I was not their agent.
Okay. Then what were you?
I was their friend, and beginning July 9th, I was their attorney in a circuit court case. And they didn't file.
I know what, I know what, I'm not gonna go through what you want, what name you want to place on it. Counsel, you know how the terms agent are defined under Michigan law. So the fact that you are somebody's friend does not mean, for the purposes of agency law, that you may not be acting as their agent.
Well, that one would have to prove I was acting as an agent rather than a friend in order to put the official title as an agent.
Ms. Tope, I don't even know how that comes out of your mouth. If you're saying that they had money and repairs that needed to be done on property that they lease, they own the property that they're leasing, and that you, whatever name you want to place on it, take funds as the only signatory to an account of theirs and do things with it, reference the property, pretty much acting as their agent.
I will prepare withdrawal papers and have them sign it. We've talked about this. They're in agreement after this.
Then why don't we start there? Nothing. All right. So you're going to withdraw as counsel?
Yes.
All right. And then, folks, are you in the position right now that you have counsel, or how? No. How much time would it take you folks to get an attorney? What do you think?
I wouldn't know where to start, so I have to look into that.
We typically offer.
Pardon?
You typically suggest.
Well, I don't know. I don't want to bring you back for a hearing and you don't have someone to represent you, but I am about to go into December. December, the escrow is going to have to be paid. So while plaintiff's not getting it, it's going to have to be paid to the court. And escrow was deposited with the court. If you don't know that, it did get deposited.
Your Honor, I received a handwritten note. I couldn't read it, but that's good to hear that they did follow.
A handwritten.
I received a handwritten note that I don't know what.
Oh, that was my written request because the court was not available Friday after our hearing. That we went to the clerk to pay the escrow, and we were told that we had to get permission from the court
to pay it in certified funds as opposed to cash. Yes,
they paid it. Okay.
And I filed that with the court, and I gave you a copy so that you knew what I had done in order to try to get the amount paid. And they also advised me that since this case is really in 14A4, but they can't take funds here at 14A1.
Yes, they can.
Well, they say that it's put into a bond and it's very complicated. And
I don't care how complicated it is. They can take the money here.
Well, okay.
They don't have to drive out.
I deposited it.
It doesn't matter.
I like to drive. It was a nice drive.
Okay. So the 4125 is, my point is that is in escrow.
It has been paid.
And that I have the expectation that the 5,500 will be paid within days of December 1st. All right. So I'm going to give the wards time to find counsel. So I'm going to adjourn this to December 19th. allow them to get counsel and allow counsel to, once obtained, to get up to speed on everything that has transpired. Pardon? All right. So I'll adjourn this matter to December 19th, 2025 at 1 p.m. You said?
Yes.
1 p.m.
My client would like to say a few words.
That's fine. Yes, go ahead.
Thank you. Thank you.
I don't really want much in regard to the substance of the case, but go ahead, sir.
Thank you. Your Honor, so my background is I'm a family man with 6 children. This property is our family's entire retirement. I was adopted, worked my way through school, started a mortgage company in 2003 that's operated for 22 years without a single bad review. I've served on the board of the directors for the Arthritis Foundation and Entrepreneurs Organization. I work with the Congressional Medal of Honor Society. I spent over 10 years coaching and sponsoring at-risk youth for football and baseball, including future Maryland running back Nolan Ray. We have saved our entire life to be able to purchase this property. The tenants have been operating a business on it without paying rent. They've made false statements about me, potential future buyers. They've contacted my land contract seller to try and usurp me and purchase my debt. The land contract seller contacted me to alert me immediately and denied them. They filed a PPO against me. And I haven't even been to my property for close to a year because of how hyper hostile the experiences have been. I won't even take my family there. The PPO was denied immediately. They then sued me in circuit court before my attorney could file this eviction. This is the 4th hearing over what began as a simple non-payment eviction. They refused to negotiate. Their actions appear intended to harm my family financially. I'm simply trying to protect my property and resolve this properly. Thank you.
Thank you. And to the parties, as soon as the paperwork and the attorneys and the parties are in order, I will expeditiously get this matter to trial, if that's where we have to head. I don't have a problem doing that, but I can't set things when things are in such disarray, quite frankly. The 19th, 2025, 1 p.m. Your attorney, once you hire them, will know to file. What they're going to have to do in this case, they're going to have to file a substitution. Well, actually not. I'll need an order of withdrawal sent, and then they can file their appearance. All right.
Thank you. Thank you.
Thank you, Your Honor.
Thank you, folks. Everybody have a great holiday.
Well,
Got one more. Patrick Becker versus Daniel Wolf. In this matter, Wolf, Daniels, neither party appeared. Case dismissed. That's how my day should have gone.